Good morning, everybody. Good morning. Hello, hello, hello. Welcome. Hello, Stephanie. Good morning. Hi, hi, hi. Have a little bit of a bonus live today, or just a live, whichever you'd like to call it. Good morning. Hello, hello. Hi there. Hi, Taylorina. All right, so we've got some very interesting things to go over this morning, such that it is. So, here we go. Let me just label this. Hopefully everyone is doing well. Hello. Oh, good, good. I love that for you, Taylorina. That's fantastic. Angie, hello. Good to see you too. You know, this year on Halloween, I will be doing another special of going through the trials that had occurred then. So I'm really excited about that. We had such a fun time last year, so I wanted to take you through the transcripts of another person who was wrongly charged and convicted. That will be this year, so I'm very excited about that. So yesterday, everybody, the Central Park Five, which are five men who were wrongly accused of criminal acts, have filed a lawsuit against Mr. Trump. And I thought, well, let's go ahead and look through that lawsuit, shall we? Because it's pretty well written, actually, and it's got some really interesting information. So I thought, let's go ahead and walk through what their arguments are here. So let me grab a pen. And I think it's pretty relevant, again, to what's going on in the world. So I thought we'd go ahead and get started. So here we go, everyone. We have our plaintiffs at the top here, and Mr. Trump is the defendant here. So this case, I think, would be, oh, I know. I do. I love this. I love this too. So here we go. This is filed in the Eastern District of Pennsylvania. Now, these men, again, were wrongly accused, as we know, and Mr. Trump made some statements during the presidential debate that were incredibly offensive and defamatory, and so this lawsuit has been filed. They are asking for a jury trial. That's been demanded, and anytime you file a lawsuit, the original document that we file is called a complaint. So that just got set out. Hello, good afternoon, good afternoon. So this is a complaint. It's not too long, everyone, and I'll just go ahead and dive right in to get into the crux here of the case. So we have a civil action complaint, and this case involves false and defamatory statements made by defendant Donald J. Trump during a presidential debate that took place on September 10th of 2024 in Philadelphia, Pennsylvania. So again, you can see the reason why this is filed in Pennsylvania is because that's where the statements were made, all right? So there's our jurisdiction. Number two, during the debate, defendant Trump made several statements concerning the Central Park Five. The Central Park Five, now also known as the Exonerated Five, are five individuals who, as teenagers, were wrongfully convicted of a series of assaults that occurred in Central Park, New York City on April 19th, 1989. Number three, the Central Park Five, or Exonerated Five, is comprised of plaintiffs Yusef Salaam, Raymond Santana, Kevin Richardson, Antron Brown, and Corey Wise. Plaintiffs were wrongly convicted of crimes they did not commit when they were between 14 and 16 years old and spent their formative years of their lives in prison. So sometimes I forget how young they were, everyone. Do we all remember 14 to 16? That's pretty gosh darn young here. So yikes. Number four, in 2002, based on newly discovered DNA evidence and the confession of the true perpetrator, plaintiffs were exonerated. Plaintiffs have spent the last 2 decades attempting to rebuild their lives. At the September 10th, 2024 presidential debate, defendant Trump falsely stated that plaintiffs had unalived an individual and pled guilty to the crime. These statements are demonstrably false. Plaintiffs never pled guilty to any crime and were subsequently cleared of all wrongdoing. Further, the victims of the Central Park assaults were not unalived. The plaintiffs have suffered injuries as a result of defendant Trump's false and defamatory statements and bring this lawsuit to obtain redress. So, oh my gosh, so many years lost. I know. I mean, 14, 15, and 16. Yikes. Here are the parties. So plaintiff Youssef is now 50 years old and is a New York City Council member representing District 9. Oh, good for him. Although he brings suit here only in his personal capacity. Plaintiff Salem is a citizen and resident of the state of New York. Oh, I just came on, Kristen. I just came on just a few minutes ago. Plaintiff Raymond Santana is now 50 years old and is the author, fashion designer, and civil rights advocate. Plaintiff Santana is a citizen and resident of the state of Georgia. Number 9, plaintiff Kevin Richardson is now 50 years old and is a motivational speaker and philanthropist. Plaintiff Richardson is a citizen and resident of the state of New York. Number 10, plaintiff Antron Brown, formerly known as Antron McCray, is now 50 years old and is retired. Plaintiff Brown is a citizen and resident of the state of Georgia. And number 11, plaintiff Corey Wise is now 52 years old and is a civil rights advocate. Plaintiff Wise is a citizen and resident of the state of New York. So we've got New York, Georgia, New Jersey, Georgia, and New York. So again, the reason this lawsuit's being brought in Pennsylvania is because that's where the defamation occurred. So that is setting out who the parties are here. And then number 12, the defendant. Defendant Donald J. Trump is a Republican nominee for president of the United States, although he is sued here only in his personal capacity. So I think this is really important, right? We have all of those immunity questions out there, but none here whatsoever. Defendant Trump is a citizen and resident of the state of Florida. They've done so much good. Oh, I know. People need to understand. Oh my gosh, absolutely. So jurisdiction and venue, this court's subject matter jurisdiction because plaintiffs and the defendant are citizens of different states and the amount of controversy exceeds the sum of $75,000 exclusive of interest. So the amount of money is enough to bump it into the jurisdiction. Venues proper because a substantial part of the events or omissions giving rise to the claim occurred in this district. So again, because that's where the debate was. The court has personal jurisdiction over Donald Trump pursuant to Pennsylvania's long-arm statute. Next, we have factual allegations, everybody. All right. Good morning. Oh, Bianca. Oh, my goodness. All right. Factual allegations. A, the Central Park 5 case. On the night of April 19th of 1989, Ms. Melly was assaulted and while jogging in Central Park. I will censor some of my words so as not to offend the TikTok algorithm, everyone. On the same night, Mr. Lewis and Mr. Longland were assaulted while jogging in a different part of the park. Plaintiffs who were between 14 and 16 years old at the time were taken in for questioning in connection with these crimes. Plaintiffs would later come to be collectively known as the Central Park 5 or the Exonerated 5. While in police custody, plaintiffs were each separately subjected to hours of coercive interrogation under duress with no attorney present and often without a parent or guardian present. Now, in 1989 would have been about 20 years after the Miranda v. Arizona case was decided, so they should have been told their rights, but on the other hand, because they are under 18, it's kind of a gray area of the law how many constitutional rights actually apply to people under 18. So it's a bit controversial. Plaintiffs are all initially denied having knowledge of the Central Park assaults. However, after hours of interrogation, 4 of the plaintiffs agreed to provide written and videotaped statements in which they falsely admitted to having been present during the assaults. Plaintiff Salem did not provide a written or videotaped statement because his mother intervened during his interrogation. However, the police detectives allegedly took notes of his responses during his hours-long interrogation, in which plaintiff Salem also purportedly admitted to having been present during the assaults. The statements were contradictory, unreliable, and inconsistent with each other and with the objective evidence of assaults. In fact, plaintiffs were not involved in the assaults in any way, and their statements were the product of coercion and duress. Plaintiffs all recanted their coerced statements shortly after their interrogations. Now, it's a side note when we're talking about interrogations and their scope. Again, the Marines shortly after their interrogations. Now, it's a side note when we're talking about interrogations and their scope. Again, the Miranda versus Arizona case is what is the most important case, one of the most important. And the court has held if a confession or a statement is coerced, it's not reliable. So that's why we have to have certain stops in place, right? Because the court has held repeatedly, if you're forcing someone under some kind of physical or mental pressure, those statements are not going to be able to be used. So that's the key here. On May 1st of 1989, only 11 days after the horrendous assault on Ms. Mailey took place, and while public sentiment against these young boys was still high, defendant Trump published a full-page advertisement in 4 New York City newspapers. The advertisement alluded to the assaults in Central Park without specifically identifying the suspects and called for the city of New York to, quote, send a message loud and clear to those who would unalive our citizens and terrorize New York, bring back the unalive penalty, and bring back our police, end quote. Here, right, poison fruit. Exactly right, exactly right. A true and correct copy of the advertisement is attached as Exhibit A. On May 4th of 1989, plaintiffs were indicted and charged with attempted homicide, this one, an assault or robbery, and this abuse and riot. Again, I do need to be careful with my language here for the algorithm. Now, before I flip too much further, everyone, let's take a look at Exhibit A, since this is what they are referring to here. So we do have Exhibit A attached to the complaint here. Happy birthday. Yes, hello, happy birthday. So this is the advertisement that he took out, everyone, with the statements here. I'm going to just block this word out so we don't get into algorithm trouble. So we've got a full written out statements from Mr. Trump, all right? 4 newspapers. It says, what happened to our city over the past 10 years? What has happened to law and order, to the neighborhood cop we all trusted to safeguard our homes and families, the cop who had the power under the law to help us in times of danger, keep us safe from those who would prey on innocent lives to fulfill some distorted inner need? What has happened to the respect for authority, the fear of retribution by the courts, society, and the police for those who break the law, who wantonly trespass on the rights of others? What has happened is the complete breakdown of life as we knew it. Now, this was published in 1989, everybody, but it sounds a bit familiar, doesn't it? So he took out 4 newspaper full-page ads, putting in his thoughts on what had happened here. All right, so again, this was in 1989 when he published this. So going back then into the complaint, so they were indicted as of May 4th of 1989. Plaintiffs pled not guilty on all counts and would all maintain their innocence throughout their trials and years in prison, even when this later hindered them from obtaining parole and extended their incarcerations. Yeah, it did. It was very expensive. Plaintiffs Salam, Santana, and Brown were tried jointly between June 25th of 1990. After 10 days of deliberation, the jury convicted each of them of assault in connection with the attack on Mr. Lewis, assault and robbery in connection with the attack on Mr. Longland, assault and this in connection with the attack of Miss Mailey, and of riot. The jury acquitted each of them of the attempted homicide and another charge. Plaintiffs Richardson and Wise were tried jointly between October 22nd of 1990. After 11 days of deliberation, the jury convicted Plaintiff Richardson on all counts. Plaintiff Wise was convicted of assault and this kind of abuse with respect to the attack on Miss Mailey and of riot. He was acquitted of the remaining charges. As the Manhattan District Attorney's Office would later acknowledge in court filings, quote, the people's case at both trials rested almost entirely on statements made by the defendants during their interrogations. So again, that's pretty huge. If you have coerced interrogations and that's your entire case, that's really bad. In fact, there was no forensic evidence that linked these 5 youths to the event. Now, in 1989, we had much less DNA and kind of CSI evidence, but we still did have the ability to track some evidence down, and there was none. Plaintiff Wise was sentenced as an adult to 5 to 15 years in prison. The remaining plaintiffs were sentenced as juveniles to 5 to 10 years. While in prison in 2002, Plaintiff Wise met the true perpetrator of the attack on Miss Melly, Matthias Reyes, who was incarcerated at the same prison for a series of these crimes committed around the same time as the Central Park assaults. After the encounter, Reyes confessed to prison staff that he was the true perpetrator of the assault and this action of Miss Melly. Wow, this takes me back, everybody. Kind of having a throwback here. Following his confession to prison staff, Reyes met with the prosecutors from the Manhattan District Attorney's Office and provided details that only the true perpetrator could know. The police also performed a DNA test that conclusively showed that Reyes was the true perpetrator. Prior DNA tests on the 5 who were convicted of these crimes were negative in all respects. Following these revelations, the Manhattan District Attorney's Office reopened its investigation into the Central Park assaults. At the conclusion of a thorough reinvestigation, Nancy Ryan, the chief of the trial division of the District Attorney's Office, filed an affirmation on behalf of the District Attorney's Office recommending that plaintiffs' convictions be vacated and that the indictments be dismissed. Ms. Ryan wrote, quote, "The people's case at both trials rested almost entirely on the statements made by the defendants, but a comparison of statements reveals troubling discrepancies. The accounts given by the 5 defendants differed from one another on the specific details of virtually every major aspect of the crime: who initiated the attack, who knocked the victim down, who undressed her, who struck her, who held her, and various other things, what weapons were used in the course of the assault, and when in the sequence of events the attack took place. In many other respects, the defendants' statements were not corroborated by consistent with or explanatory or of objective independent evidence, and some of what they said was simply contrary to established fact." So that's pretty significant. Given the unreliability of the statements, as well as the newly discovered and incontrovertible proof tying Matthias Reyes to the assault, the District Attorney's Office recommended the charges relating to the attack on Miss Melly be vacated. With respect to the attacks on Mr. Lewis and Mr. Longline, Ms. Ryan stated, quote, "The trial evidence as to the other charges, like the evidence as to the attack on the female jogger, consisted almost entirely of defendants' statements," end quote. Consequently, quote, "there was no significant evidence at trial establishing the defendants' involvement in other crimes of which they stand convicted and would not have been substantially or fatally weakened by the newly discovered evidence in this matter," end quote. On December 19th of 2002, New York Supreme Court Justice Charles J. Tejada vacated plaintiffs' convictions and dismissed the indictments as the District Attorney's Office had recommended. In 2003, plaintiffs brought suit against the City of New York for, among other things, false arrest, malicious prosecution, and racially motivated conspiracy. The lawsuit settled for $41 million in 2014, with then Mayor de Blasio stating that the settlement was a moral obligation to right this injustice. So $41 million is quite a bit. That is quite a bit. But then again, what would you rather have, the money or the time back that you were in prison, right? B, the September 10th, 2024 presidential debate. On September 10th of 2024, Defendant Trump participated in a presidential debate hosted at the National Constitution Center in Philadelphia, Pennsylvania. The debate was watched live by more than 67 million people in the United States. The video and transcript of the debate have since been viewed by many others. During the segment of the debate dedicated to race and politics in this country, Defendant Trump's opponent, Vice President Kamala Harris, made the following statements. Let's remember this is the same individual, Trump, who took out full-page ad in the New York Times calling for the execution of 5 young Black and Latino boys who were innocent. The Central Park Five took out a full-page ad calling for their execution. Vice President Harris's comment came as a part of a longer answer relating to race and politics. Defendant Trump responded, quote, "They come up with things like what she just said, going back many, many years, when a lot of people, including Mayor Bloomberg, agreed with me on the Central Park Five. They admitted, they said they pled guilty. And I said, well, if they pled guilty, they badly hurt a person, unalived a person ultimately. And if they pled guilty, then they pled we're not guilty." End quote. Yikes. Defendant Trump's statements came as part of a longer response to Vice President Harris's comments. A true and correct video recording of the debate is available at the following link here. The relevant portion of the debate can also be accessed at the following link here. Defendant Trump's statements were concerning plaintiffs collectively known as the Central Park Five. Defendant Trump's statements were false and defamatory in numerous respects. Plaintiffs never pled guilty to the Central Park assaults. Plaintiffs are all pled not guilty and maintained their innocence throughout their trial and incarceration, as well as after they were released from prison. None of the victims of the Central Park assaults were unalived. Michael Bloomberg, referenced in Mr. Trump's remarks, would not become mayor of New York until 2002. The mayor at the time of the Central Park assaults was Ed Koch. Mayor Koch did not agree with defendant Trump's statements regarding the assaults. In fact, in the 1989 advertisements, defendant Trump acknowledged Mayor Koch has stated that hate and rancor should be removed from our hearts. I do not think so, end quote. In response to Mr. Trump's advertisement, Mayor Koch was quoted as saying, quote, "Nobody I know of in Western society believes that under any circumstances would you ever impose the unalived penalty on juveniles." Further, during the 1989 interview discussing the Central Park Five, Mayor Koch carefully noted, quote, "We always have to say alleged because that's the requirement," end quote. Defendant Trump also omitted key facts, further rendering his statements false, misleading, and defamatory. These include, among other things, the fact that the Manhattan District Attorney's Office later acknowledged that the teen's confessions were unreliable and conflicted with the objective evidence, that 4 of the 5 were acquitted of attempted homicide, that all of the 5 men's convictions were later vacated, and that the true perpetrator, Matthias Reyes, confessed that DNA evidence confirmed Reyes was the true perpetrator, and that the city of New York ultimately agreed to pay $41 million for its conduct towards plaintiffs. Defendant Trump's statements of or concerning plaintiffs on September 10th of 2024 were made negligently, with knowing of their falsity and or with reckless disregard for their falsity, which are the intent elements needed for defamation. Defendant Trump's false and insinuating statements about plaintiffs were defamation per se, in that they ascribed to plaintiffs the commission of criminal offenses, including offenses for which plaintiffs have never been charged or accused, offenses for which they were acquitted at trial, and offenses for which they were conclusively exonerated and their convictions vacated. So this is in reference to Mr. Trump saying that the victims were unalived. All right, so that part of his statement is just patently false. Defendant Trump's statements about plaintiffs were also defamatory per se because the Central Park assaults involved false. Defendant Trump's statements about plaintiffs were also defamatory per se because the Central Park assaults involved false. Defendant Trump's statements about plaintiffs were also defamatory per se because the Central Park assaults involved this crime, and thus, by ascribing the commission of assaults to plaintiffs, defendant Trump was also ascribing to plaintiffs serious misconduct, which is here. Again, I am watching my language for the algorithm here. Defendant Trump's conduct on September 10th debate was extreme and outrageous, and it was intended to cause Defendant Trump's conduct on September 10th debate was extreme and outrageous, and it was intended to cause severe emotional distress to plaintiffs. And that's a big deal, too. Plaintiff Salam Salem attended the September 10th debate in person, whoa, and was in the room when Defendant Trump made his false and defamatory statements. Oh my gosh, yikes. What? Whoa. After the debate, Defendant Trump passed through the post-debate spin room fielding questions from attendees. As Defendant Trump approached Plaintiff Salem or Salam, other attendees asked Defendant Trump, "Will you apologize to the exonerated five? And, sir, what do you say to a member of the Central Park Five, sir?" When Defendant Trump did not respond, Plaintiff Salem said, "President Trump, I'm Yusef Salem, one of the exonerated five. How are you doing?" Defendant Trump responded, "You're on my side then." Well, Plaintiff Salem then said, no, I'm not on your side." Defendant Trump proceeded to wave his hand at Plaintiff Salem, smile, and walk away. Oh my gosh, whoa. That's huge. So not only were the statements made on television or broadcasted, but they were made with one of the plaintiffs in the room. That's huge, everybody. Plaintiff Salam was attempting to politely dialogue with Defendant Trump about the false and defamatory statements that Defendant Trump had made about plaintiffs less than an hour earlier, but Defendant Trump refused to engage with him in dialogue. A recording of the exchange can be accessed at the following link set here, which is exonerated5versustrump.com. Oh my gosh. Okay, C. So Defendant Trump's pattern of wrongful conduct towards plaintiffs. Defendant Trump's conduct on September 10th debate was part of a continuing pattern of extreme and outrageous conduct towards plaintiffs stretching back decades. Yikes. Defendant Trump has previously made numerous public statements demonstrating he is familiar with the Central Park assaults, the criminal case, the trials, the exoneration, and the settlement with the city, and that he therefore knew that the statements he made on September 10th of 2024 were false and misleading. Like in his statements on the September 10th debate, many of Defendant Trump's past statements are themselves false, defamatory, and a part of continuing pattern of extreme and outrageous conduct directed at plaintiffs. By Defendant Trump's own admission, his conduct towards plaintiffs is born out of his personal animus and an intent to make the men suffer. As Defendant Trump stated in his 1989 advertisement, quote, "I want to hate these muggers and murderers. They should be forced to suffer. I want to hate these murderers, and I always will. I'm looking to punish them. I want them to understand our anger. I want them to be afraid." Oh my gosh. On April 24th of 2013, Defendant Trump tweeted his impressions of a documentary film about the Central Park Five, or Exonerated Five, which he described as one-sided piece of garbage that didn't explain the horrific crimes of these young men while in park. Whoa. Defendant Trump was referring to a 2012 film by documentarian Ken Burns titled The Central Park Five. The documentary describes in detail the true circumstances of the Central Park assaults, the subsequent legal proceedings, and the men's ultimate exoneration. The film explains that the Central Park Five, or Exonerated Five, never pled guilty and that the victims did not die or did not unalive. So they're saying this to show that Mr. Trump knew what he was saying was false, because he had commented that he had seen this documentary, so he would have this level of knowledge, again going to his intent. Given that Defendant Trump has seen the film, he knew his statements at the September 10th debate were false, misleading, and defamatory. Right, so that's what I just said. I'm getting ahead of myself here. All right, Defendant Trump falsely stated in his April 24th, 2013 tweet about the documentary that the Central Park Five committed horrific crimes while in park. The statement, written long after plaintiffs had been exonerated, was itself false, defamatory, and part of a continuing pattern of extreme and outrageous conduct. On June 29th of 2013, a Twitter user asked Defendant Trump, quote, "How do you feel that the Central Park Five were innocent?" End quote. Defendant Trump responded, quote, "Innocent of what? How many people did they mug?" End quote. Oh. Defendant Trump did not claim in his tweet that the plaintiffs had pled guilty to assaulting and unaliving someone like he did at the September 10th debate, because he knows that this is false. However, Defendant Trump stated in his June 29, 2013 tweet that plaintiffs were guilty of mugging. The statement was itself false, defamatory, and part of a continuing pattern of extreme and outrageous conduct. On June 21st of 2014, Defendant Trump wrote an editorial in the New York Daily News regarding the civil settlement with the city of New York, in which he called the settlement a, quote, disgrace, end quote, stated that, quote, these young men do not exactly have the pass of angels, end quote, and asked rhetorically, quote, what about the other people who were brutalized that night in addition to the jogger? Defendant Trump did not claim in this editorial that plaintiffs had pled guilty to assaulting and unaliving someone like he did at the September 10 debate, because he knows that this is false. However, Defendant Trump's derogatory comments and insinuation of criminality directed at plaintiffs in his editorial were themselves false, defamatory, and part of a continuing pattern of extreme and outrageous conduct. On June 18th of 2019, Defendant Trump was asked by a reporter, quote, the Central Park Five, they've been exonerated. There have been movies and videos. You came out with a full-page ad saying they should unalive. They should have the unalive penalty, end quote. Defendant Trump responded, quote, why do you bring that question up now? It's an interesting time to bring it up. You have people on both sides of that. They admitted their guilt. If you look at Linda Farstein and you look at some of the prosecutors, they think that the city should never have settled that case. So we'll leave it at that, end quote. Wow, that was in 2019. Defendant Trump did not claim in his response to the reporter that plaintiffs had pled guilty to assaulting and unaliving someone like he did at the September 10th debate, because he knows that this is false. However, the clear implications of Defendant Trump's statements was that Linda Farstein, a prosecutor of the Central Park assault case, continues to believe that plaintiffs were rightfully convicted of assaulting and harming Miss Mellie. In fact, while Ms. Farstein has made some negative comments about plaintiffs, she nevertheless wrote in the Wall Street Journal editorial on June 10th of 2019, less than 2 weeks before Defendant Trump's statements, quote, Mr. Rice's confession, DNA match, and claim that he acted alone required that the certain kinds of charges against the Fives be vacated. I agree with that decision and still do. So she wrote that June 10th, and he made his statement June 18th. Defendant Trump also omitted the fact that Manhattan District Attorney Robert Morgenthau and Chief of the Trial Division Nancy Ryan, who were responsible for overseeing the prosecution, formally recommended that all charges against plaintiffs be vacated and that indictments dismissed. The tea break. Oh, you read my mind. This further renders Defendant Trump's June 18, 2019 statements regarding the views of prosecutors on the case false and misleading. Defendant Trump's false and misleading statements to reporters on June 18th of 2019 were part of a continuing pattern of extreme and outrageous conduct towards plaintiffs. Plaintiffs suffered harm, including severe emotional distress and reputational damage, which is a huge factor that was also in the Carroll cases, as a direct result of Defendant Trump's false and defamatory statements at the September 10th debate, as well as his continuing pattern of extreme and outrageous conduct. So those are the facts set out here in the complaint. Again, this was filed yesterday, everyone. So let's take a look at the causes of action. So this is where they actually set out what laws have been violated here. All right. And again, civilly, this is a civil case. Count number 1, defamation. Plaintiffs incorporate by reference the averments contained in the foregoing paragraphs of the complaint as though fully set forth herein at length. Defendant Trump published the above-mentioned statements, innuendos, and implications concerning plaintiffs, including to individuals of the Eastern District of Pennsylvania. The aforementioned statements were of or concerning plaintiffs, also known as the Central Park Five. Individuals who heard said statements, innuendos, and implications understood them to refer to plaintiffs. The statement's innuendos and implications were defamatory per se. Defendant Trump knew his false and defamatory statements negligently, knowingly they were false, and or without reckless disregard for the truth or falsity. Again, these are the elements for defamation. Defendant Trump made his false and defamatory statements with ill will and spite, and with wanton, reckless, or willful disregard for their injuries, their injurious effects on plaintiffs. Especially when one of the plaintiffs was in the room at the time. My goodness. As a proximate result of defendant's negligent, malicious, intentional, and reckless conduct as set forth above herein, plaintiffs are entitled to such damages as will compensate them for their reputational damage, emotional pain and suffering, resultant out-of-pocket costs and expenses, and punitive damages to punish defendant Trump for his conduct and deter him and others similarly situated from like acts in the future. So we have compensatory damages here, reputational, emotional pain and suffering, costs, of course, and then punitive damages, which are those huge numbers of damages in order to the only purpose of punitive damages are to punish the wrongdoer. So that's where we get those huge numbers, like in Giuliani's case, where he was sued by the two women in Georgia. The punitive damages are what take it over the top for the amount. And those are a special kind of damages when a defendant is absolutely in the wrong. So those are being requested here. Wherefore, plaintiffs demand judgment against defendant Donald J. Trump for compensatory damages, punitive damages, and costs in an as yet unliquidated sum in excess of $75,000, which is determining which court to be in, and such other relief as this court deems just, and for trial by jury on all issues so triable. So that's count number one. Count number two, false light. Plaintiffs incorporate by reference the averments contained in the foregoing paragraphs of the complaint as though fully set forth herein at length. Defendant Trump's statements placed plaintiffs in a false light that would be highly offensive to a reasonable person. Defendant Trump knew that his statements were false and or acted in reckless disregard as to the falsity of his statements and the false light in which they would place plaintiffs. Defendant Trump made his false and offensive statements with ill will and spite, and with wanton, reckless, or willful disregard for their injurious effects on plaintiffs. This is going to be difficult to prove in court, this particular piece, but it certainly can be done. And if you take his statements and his history together, there's quite a bit of evidence that could be presented showing that he knew that. As a proximate result of defendant's negligence, malicious, intentional, and reckless conduct, as set forth above and herein, plaintiffs are entitled to such damages as will compensate them for reputational damage, emotional pain and suffering, resultant out-of-pocket costs and expenses, and punitive damages to punish defendant Trump for his conduct and deter him and others similarly situated from acts in the future. All right, and then we're coming down to the final pages here. Wherefore, plaintiffs demand judgment against defendant Donald Trump for compensatory damages, punitive damages, and for costs in an as yet unliquidated sum in excess of $75,000, and such other relief as his court deems just, and for trial by jury on all issues so triable. So note they're asking for a trial by jury. That's important. As attorneys, if your client wants a trial in front of a jury, don't forget to ask for it. Count 3, intentional infliction of emotional distress. So this particular tort or a civil offense is difficult, is one of the more difficult ones to actually prove and win on in court. Not impossible, but it is difficult. So it's kind of a gray area of the law that will really depend on how strong your case is and the kind of jury that you pick. So voir dire would be very important in order to go forward on this kind of a charge. So plaintiffs incorporate by reference the averments contained in the foregoing paragraphs of the complaint as though fully set forth herein at length. Defendant Trump's conduct towards plaintiffs at the September 10th debate was extreme and outrageous. So again, this level of proving it being extreme, what makes it extreme and what makes it outrageous. Defendant Trump's conduct towards plaintiff at the September 10th debate was part of a continuing pattern of extreme and outrageous conduct dating back several years, thus constituting a continuing tort. So this isn't something in criminal cases we have to be very careful about showing habit or modus operandi evidence. We have to be very careful. But in a civil case, the rules are a bit more lax with regards to what evidence can come in on habit or showing this continuing ongoing behavior. Defendant Trump's conduct intentionally and or recklessly caused plaintiffs to suffer severe emotional damage or emotional distress, which an expert can be called in to show that. Defendant Trump acted with ill will and spite and with wanton, reckless, or willful disregard for his conduct's injurious effects on plaintiffs. So this one is what's going to be the kicker in this count. That's very difficult to prove because we're going to be going into what actually Mr. Trump was believing or understanding at the time. So you're going to have to pull in all of that circumstantial evidence, as well as perhaps witnesses that have heard Mr. Trump talk about it, those kinds of things. This can be very difficult to prove, but it is possible. As a proximate result of defendant's malicious, intentional, and reckless conduct, as set forth above and herein, plaintiffs are entitled to such damages as will compensate them for their emotional pain and suffering. Resultant out-of-pocket costs and expenses and punitive damages to punish defendant Trump for his conduct and deter him and others similarly situated from like acts in the future. So it's not only a punishment, but it's also for deterrence effect. Wherefore, plaintiffs demand judgment against defendant Donald J. Trump for compensatory damages, for punitive damages, and for costs in an as yet unliquidated excess of $75,000, which again has to be stated in order for them to be in the proper jurisdiction. If it was less than $75,000, we'd be in a different court. And such other relief as this court deems just and for trial by jury on all issues so tribal. And here's our prayer for relief, which is just a boilerplate language that we use in all of our complaints and motions. Wherefore, plaintiffs respectfully request that the court award plaintiffs compensatory and punitive damages in an amount to be determined at trial, along with pre- and post-judgment interest, costs, and such other relief as the court deems just and proper. Demand for jury trial. Plaintiffs demand a jury trial on all issues so tribal pursuant to Rule 38 of the Federal Rules of Civil Procedure. And then this was dated October 21st. So there you have it, everybody. That's a pretty well-written complaint here. Pretty straightforward, too, where they've got those direct quotes from Mr. Trump. And again, the fact that one of the harmed parties was in the room when he made those statements. And of course, you're going to, one of the biggest pieces of this case would be having the plaintiffs testify, right? So they would be testifying about how this affected them, how this emotionally distraught they were, and the harm that was done to them as well. Yeah, this is pretty hardcore. Now, again, if we look at the big picture of the Trump trials, right, that we're kind of watching as time goes on, we've got the 4 criminal trials, one that's on appeal, right, the Florida case is on appeal, and then we have countless civil cases. We've got the Blessing Game case along with a dozen, maybe 24 other cases civilly that Mr. Trump is involved in. So we've got defamation, of course we have the Carroll cases, we have lots of other places where he's used music he wasn't allowed to or whatever, and he's being called out on it. But this case, everybody, this one is pretty hardcore. This one, I would say, out of all of them that I have read, is the most cut and dry when it comes to the evidence. Plead incompetence if he medical records that show he's actually has dementia. Yes, he can. So, but we got to be careful. I say I'll say a soft yes, okay, to that, because proving insanity or incapacity in court is different legally than medically. You can have a medical record of dementia, but when pursued in court, be found competent still. So it's really going to depend. It doesn't necessarily mean automatically you're incompetent. It means that those records and those things can be brought during a competency hearing, but you could still be deemed competent. That's where one of the problems with our legal system, where the law and science conflict with each other, is in those competency cases. Has anyone ever been sued more than him? I would say no. I would say no, not that I know of. I mean, maybe the owner of Walmart, but I can't think of anyone. And in fact, this is so fascinating to have the same defendant throughout all of these cases. It's like, wow, okay, we don't have to like go through and say, well, who's the defendant this time? Like, we all know who it is. It's a fascinating way of learning the law. Didn't have to mention when he printed those ads in the 80s. True, true. He can't claim incompetence or he won't be able to be president. Well, that's a good point too, Amy. Again, the competency, again, is not a medical term in a court. It's a legal term. So, again, depending on how the 25th Amendment gets invoked, which has to do with not being able to be president, that, again, is another kind of competence. So, but absolutely, absolutely. Seems to be purposeful. Yeah. Can we all just do a class action suit having to listen to him for all these years? That's funny. If only we could, everybody. I'd draft that complaint, but alas, no. We have to make sure that the harm is directed towards a specific person. That's why this case is so strong, because we have literally the 5 men who were harmed. He directed his comment directly towards them. So each one of them now has standing to bring this defamation lawsuit. So for you or for me, I don't think he specifically mentioned us, right, in a derogatory or defamatory way. So unfortunately, only the people he like singles out can actually have grounds to sue. And that's just too bad, but unfortunately, yes. He may try, perhaps. Why has he not been disqualified as a candidate for his conduct? Well, that's a great question, and that is because the United States Supreme Court refused to do that. They had an opportunity when the Anderson case hit the Supreme Court, where Colorado had disqualified him, but they chose not to do that because they're jerks. Okay, because they're big jerks. That's why. Supreme Court equals jerks. But yeah, he should have been, in my opinion, if they had actually read the Constitution without being jerks. I think he would have been disqualified in a lot of states, actually. And hopefully that will someday be overturned by a Supreme Court that is not full of jerks. There's this calling. Well, right. Enemy within. Right. Now, if he starts getting specific, everybody, you can absolutely go forward. Person, woman, man, camera. Oh, my goodness. Elephant, right? Got you. If he wins, he can appoint. Right. I mean, again, so the big thing in 2016, many people probably don't remember this. One of the big reasons why what the election was about was like, hey, our Supreme Court is going to get stacked by the next president. But that didn't really seem to really affect people. Like, that wasn't necessarily their biggest deal. So they didn't care, or they wanted Mr. Trump to have that power. So that's why he was put in the White House. So, I don't think it's stating it incorrectly by saying our Supreme Court is in the hands of the next candidate. I would agree that is true and something that people should consider. But his mental health, when he talks about taking the enemy from within. Yeah, so he's, oh my gosh, everybody. I mean, I'm not a medical doctor, and so I certainly cannot go into any kind of medical diagnosis. I barely understand science, all right? I'll confess right now, me and science aren't really friends. But it does seem a bit odd. Like, I have a grandpa. I have a very old grandpa. And I would not want my very, very old grandpa to be in charge of the nuclear codes. You know what I'm saying? Like, I would be like, come on, Gramps, let's go sit in the swing and chat. You don't need to, like, take over the world. So that's kind of where my stance is on this situation. Like, I'm not diagnosing anybody. I'm just saying, I've got a really old grandpa, and I don't think that's necessarily what's best for the country, in my opinion. Pelosi, yeah, I know, right? I mean, if you sit and listen to your grandpa go on and on, everybody, you know what I'm saying? You know what I'm saying? He's not quite, his ticker's not quite ticking the way it used to long ago. Oh my gosh. They do less damage when they're on break, for sure. I wish we had younger presidents. Well, now Vice President Harris did just turn 60, I think, yesterday. I think 60 is an okay age. Younger presidents. Well, now Vice President Harris did just turn 60, I think, yesterday. I think 60 is an okay age, right? I think when you start getting into those now, again, I hate to make blanket statements because there are some people who are hitting their strides when they're hitting 70s, but those are rare. Those are not, that's not the usual. In the 70s, like you should be on a carnival cruise, you know, going and exploring the islands you didn't get to because you're working too hard. Like that's what you're supposed to be doing. You're not supposed to be like pulling people out of like, you know, decades long peace agreements and such, in my opinion. Oh my gosh, like you don't need to be doing that. 60's a new 40. Oh my goodness. Oh my goodness gracious, everybody. Well, we'll see. We'll see. You know, several people have made the point that if Mr. Trump does lose the election, which again, you know, for me, I feel like it's 50-50. I'm not a poll person, never have been. The only thing that I think really shows a future prediction of who may win has to do with the number of new voters and the quantity. If we get the highest numbers ever and the most new voters, those races tend to go to the Democrats. When you have a poor turnout, historically, that tends to fall with the Republicans. So that's kind of how that works if you just look at the stats numbers. So don't base it on polls. But depending on what happens, you know, he may be on a yacht somewhere trying to escape all of these lawsuits. Because this lawsuit, everyone's going to take 5 years minimum. It's going to take 5 years without a doubt. But it will haunt him because I think these plaintiffs are truly, truly in it to win it. And that means they're going to, every single time there's a dismissal, they're going to fight it. Every single time that they're saying there's immunity, they're like, forget it. They're going to fight it. So we've got some fighters here that are going to keep him on the hook for years to come. And this basically is an untouchable lawsuit where he can't claim it was actions when he was president that don't count. This is something that is going to be preserved and will age well for the plaintiffs and not the defendants. Face them in court, I think it's absolutely possible. And, you know, the other thing, too, during the discovery phase, during a civil case, you have to remember, he'll go through a deposition. He'll be writing out interrogatories. He will have under oath statements he will be required to make because of questions. That's part of the process here, too. So even if we don't have a full-blown jury trial, within the next, I would say, 18 months, 24 months, we could very well see a very damaging deposition taken, which is just, you know, the same that could be used against him in court. So this case is absolutely solid. We don't have any, you know, kind of huge questions here. But as I've always said with a jury trial, it's 50-50. We never know which way it'll go. But the process of getting this to trial could be very damaging for him. Good morning, Thomas. Yes, Kristen, 18 months, 24. I mean, and that's like on the quick end of it. Our lawsuits move pretty slowly, everybody. I'm not sure if you've noticed that. They're slow moving. Chances of a settlement? Great question. And I would say 0 based off of Mr. Trump's past behavior. If he was going to settle, he would have settled the E. Jean Carroll case. That was probably one of the biggest legal mistakes that he has made, is having that case go to trial. Yeah, it costs a lot. It costs a lot. Oh, no worries, no worries. So yeah, sue the lady who accused him and the DA also. Could be. It's possible, but again, I mean, he has this huge platform, right? He had 67 million people watching, and one of the plaintiffs was in the room at the time. So I mean, this is a very personal situation. Has organized her, got everyone registered. Oh, I love that. Oh, good for her. Yes, go register to vote, everybody. Make sure you're voting. Get your voting plan in place. Vote, vote, vote. That's so important. I'm not going to tell you who to vote for. I'm going to say, just please go and vote. Political warfare. Well, yeah, I mean, again, I think Mr. Trump really struggles, in my opinion, Mr. Trump struggles with this idea that you can't just say whatever you want. And, a lot of people come onto my page and they'll go through my First Amendment posts, or they'll look through any of the First Amendment cases that put restrictions on speech, because it's not absolute. No right is absolute. No right. And they get very upset and they're like, no, these are like, God-given rights. I'm like, well, no, first of all, no, they're constitutional given rights. But second of all, you can get into trouble for what you say. You certainly can. You can get sued for defamation. You can get charged with harassment. There's all kinds of things that can happen to you legally from just your words. And I think Mr. Trump is really struggling to understand that. Or if he does understand it, he just doesn't care, and he's willing to take the hit against him. And I think over time, the sheer quantity is going to be his undoing, in my opinion, when it comes to speaking stuff without recognizing there has to be some kind of understanding. You can't harm other people with your words. Yeah, I saw that, Deanna. Elon Musk is paying like $1 million randomly to people. I mean, what? That's crazy. That's ridiculous. But, to each their own. I'm not sure there's a law that would prohibit that from him just giving $1 million randomly to people. But I don't know. I thought he was running out of money. Did I miss that? I thought after Twitter, he was like in a sinking ship and didn't have any more money. Like, I don't know if he should be just handing out millions of dollars, because it's not like he's going to get hired somewhere else. He needs to save that money to get him through the rest of his life. You know what I'm saying? Oh, yes. Oh, well, Desert Skies, that's so sweet. I'm glad to be back. I'm very glad to be back. You think there is a law against it? Could be. I don't know. I don't know if I've ever heard of a case where someone's like, I'm going to randomly give you $1 million. Like, I'm not sure. It'd be hard to prove. Well, fair enough. Yeah, and his child support. Oh my gosh. Oh, the child support, everybody. Right. Have registered to vote, so they're saying it can be, well, I don't, it's 12 kids. My goodness. I'm not sure. I mean, don't get me wrong, everybody. I think, you should have however many kids or not any kids, whatever you want. But if you do have kids, you should make sure that you are being a responsible parent. So... that's unusual. Wouldn't it be buying a vote? Well, it certainly seems like it, doesn't it? But again, you can kind of move your words around a little bit. Like, no, we're just encouraging people to, use their own rights. Like, you can kind of twist that around. Mention that it was against election laws. Well, and I tell you what, if there's a place where they're going to say something is illegal, it's going to be Midas Touch. Absolutely reliable source when it comes to the legal breakdowns, absolutely trustworthy. So I have yet to see a single mistake that Midas Touch has made when it comes to talking about specific laws. So they do good work. So if they say it's against the law, I believe that. I would. For Trump to offer prizes and donations and then not award them? That's a great question. And if you'll remember, we did have the MyPillow guy, right? MyPillow guy who said, show me that there's no evidence of fraud and I'll give you $5 million, right? Something like that. So the guy did. The guy was like, here's the evidence. And he's like, I'm not going to pay you. And he got taken to court and he had to pay him. So, I mean, there are definitely modes of redeeming promised money when someone's offering like that. So it is possible. Yeah. Lest we forget the MyPillow guy, which I know Amanda is the one that I keep up on. She keeps me up to date on the MyPillow guy left and right, and I'm so thankful for that. I can't keep track of all these people, everybody, so I'm very thankful. So Amanda, keep up with the great work you're doing. I appreciate that. Oh, regardless of what's going on, I'm waiting for the IRS to jump in. Murray, it's a slow-moving tank, but alas, a moving tank nevertheless. So I have no doubt the IRS is going to come in here pretty soon. Very, very soon. Yeah, the MyPillow guy. She's the Lindell whisperer. I think that's so true. That's so true. Oh my gosh. Yes, incredible work she does over there. Oh, the airplane. Yeah, I remember that one too, right? He's like, I want the jet. Like, what? You can't have the jet. Oh my gosh. Yes, yes. I think Midas Touch does good work. I don't always agree with their interpretation, and that's how things are supposed to be. You don't have to agree with everything. You don't have to fall in and say, "Well, that's absolutely right." I don't always agree with their theories, but when it comes to straight facts and the law, absolutely, they do great work. So. Is there a GoFundMe for? I don't know. That's a great question. They do have a website that they list out here, which is, let me pull that website again. Where was our website? Here we go. The Exonerated 5 versus Trump.com. So it looks like this lawsuit and probably any kind of link to assist them would probably be in that website there. Keeping a low profile. Yeah, I think after he shaved his mustache, I think he was, he's like, I gotta go. I don't know. That was like a big thing. Like, I didn't know that was gonna be like, really? There's that much interest in his mustache? All right. My pillow guy's broke. Owes money's a hot mess. Oh no. I just, oh my gosh. Well, right, exactly, Friday. I mean, of course, this is why a lot of attorneys become attorneys, is to go forward on a case like this, to truly call someone out for an injustice that is occurring. And there are those young attorneys or even some seasoned attorneys with stars in their eyes saying, I'm here to make a difference. And, they're going to come in and do amazing work. And so we love them. We love those attorneys. I am not one of those attorneys. I no longer have stars in my eyes. I barely have eyes. But the youngins out there, the ones that aren't burnt out, they're the ones coming in and going forward on these cases, and they're amazing. So we're very thankful for that. Very thankful. Oh my goodness. So I have no doubt. Yes, most that get close to Trump end up in the poorhouse. Well, they kind of do. I mean, a lot. There certainly are a lot. I mean, again, we still have the New York corporate fraud case, which brought down, multiple people. And, there's several other cases involving that as well. It's a lot of work to see. Absolutely, it really is. It takes a level of dedication and a desire to fight the good fight in order to keep pursuing it. And plaintiffs too. That's why I feel like this is a really good case, because I feel like the plaintiffs are so strong that they'll be able to withstand the fight ahead of them. And, that's amazing. It's sad that they have to go through it. It's unfortunate. But if you wanted to pull a group of people that can, keep going forward no matter the fight, I would say these guys are the ones. So for sure. My true story, VC. They put up, yes. Well, we'll see. He's kind of got an ongoing shtick going with these. It's almost like the reporters know what those trigger words are for Mr. Trump. And if they just spit a trigger out and they can get him to hook on it, so they're baiting him, and then he'll say something that's like, dude, that's defamation. Like, you need to have a little person next to you, or a big person, doesn't matter the size. You need to have someone next to you being like, sir, that's defamation. Or just hold up the defamation law. Just hold it up and show it. Like, when I'm holding this piece of paper, Mr. Trump, it means you're saying something you can get sued for. So watch the paper. You know what I mean? Like, put a red flag up or something. Someone needs to be spotting him, or he's going to continue to just get sued, because he is unable to wrap his head around the First Amendment not being absolute. You can't just say whatever you want. So you really do. Yes, YSL is a huge drama show. I had to back away from that one. That's pretty ugly. That indictment's pretty crazy too. Love the nails. Oh, thanks so much. He knows he doesn't care. Well, I think, again, he's willing to take the hit for it. I think he knows, but thinks it's wrong. He doesn't think that there should be any kind of limits on the First Amendment. And kind of like what Musk was saying when he took over the Twitter. He was like, you should be able to say whatever you want. It's like, well, that's not actually how the law works, sir. Think he would listen to warnings? I don't know if he'd listen, but at least he'd have notice. Like today I got 3 red flags, so I've got 3 lawsuits coming at me. It would be a counting system for him. He can figure out how many people we're going to sue him tomorrow. Oh, okay. Yeah, I've been on for a little while. Oh no, did the invite not come on? Oh, I'm sorry about that. Country are you in with? Oh, I don't know about that. That's why they keep him off the witness stand. Well, true story. But what you don't want is a client fighting you to get on the witness stand. That's the worst. That's the worst situation. When you tell your client there's no way this is going to turn out okay for you, and they're like, I don't care, I'm going to do it anyway. Then you just sit at that table, at counsel's table, and you just are like, well, so that happened. Thinks he knows what he doesn't know. Oh, true. Oh my gosh. Bob Woodward, everybody. Amazing person. He did such amazing work. I've been listening on Audible to several of his books, and one of them on the Trump tapes, he says at the very beginning, he's like, I have to admit, even I got sucked in and had to pull myself out of the vortex that is Mr. Trump. Like, you said it, man. Yes, so Central Park 5, again, just to kind of summarize what we've been going over. Central Park 5 filed a lawsuit against Mr. Trump just yesterday for the statements Mr. Trump made about them, claiming that they had unalived someone and that they had pled guilty, which are blatantly false, incorrect. He made those statements during the presidential debate. So they are suing him for defamation and emotional harm, and trying to come in and say, hey, look, dude, we never pled out to this, and this whole situation was awful, and what you're saying is incorrect, and you know that, and you're doing that in a mean way. So that's why they have filed this lawsuit, which was yesterday. Glad to catch you. Yes, I'm doing great. Thank you, Can. Really, I haven't seen his new one yet. They deserve all his money. I agree. I don't know, everybody. I tell you what, it baffles me. Again, all I see is like my grandpa running around. Like, who would give my grandpa that much power? Like, nobody. And you know it. Like, you know it. Like, all these young people are like, woohoo, yay, he's great. I'm like, really? Are you sure? Are you sure about that? Because I'm not sure. I'm not so sure about that. What about the statute of limitations? Great question. So the statute of limitations for a criminal case would be long past, right? But this is a defamation, and the defamation occurred on September 10th of 2024. So that's when the statute starts running. So as long as they're within, and I'm not sure federally where we've got our Eastern District of Pennsylvania, I'm not sure exactly what the statute of limitations is for that. Typically they're 2, 3, or 5 years in civil court. So he would have like 2 years. They'd have 2 years typically on the shortest line to bring it. So September 10th of 2024 is when that statute starts to run. So a jury trial in Pennsylvania could be very dangerous. True. I'm so tired. Oh, I know, everybody. I think everybody's getting tired of it. And, again, it's like, well, Grandpa needs to take a break. He needs to just, calm down. But honestly, I think Mr. Trump realizes that if he stops, that he's going to get caught. And at some point, all of this is going to come tumbling down if he stops moving, so he's got to keep moving in order to stay out of the mess that he will eventually be in my opinion. It is exhausting. It really is. And I don't think people realized how long lasting this was going to be. I mean, I spoke with a lot of people in 2016 that are like, why'd you vote for him? Well, I just wanted to burn it all down. Or he's something new and different. And I'm like, okay, I get it. But in 2020, he's not something new and different. He's different, but those same kind of thoughts aren't there anymore because he's got a record. You can see what he did for 4 years. And here we are again, where he's still running. He's still trying to, again, keep from stopping. Because if he stops, as my grandpa would say, if you stop moving, the devil will come and get you. So I think that's very true in this situation as well. Oh my gosh. Oh, afford groceries. Well, right. I mean, again, you have to take a look and see what's really going on. Is it the fact that you can't afford groceries, or is it a company that's, putting 12 ounces in where there used to be 24 ounces and then charging twice as much? So, you got to figure out who's the one actually jacking your grocery prices up. I think that's a fair question to ask because it's not benefiting the farmers. I'll tell you that much right now. He needs prison time. Well, some people believe that. Some people believe that Democrats are destroying America. I don't think you can pick one party and do a blanket statement that they are the cause of all of the harm. I don't think that is true for anybody. I don't think you can say that for the Republicans, such that they are. I don't think you can just pick a party and then make them the ones at fault, because if you do that, if you say one group of people is at fault, now we're back in World War II, right? We're back with that same ideology that there are people that are less than human and they're the ones creating the problem. And we don't want to go back there, right? We don't need to go back down that road. So I don't think we can, again, just do a blanket statement and says there's a group causing all of this mischief, because it takes two to tango. You know what I'm saying? So lots of people are at fault here. People are so stuck in the tunnel vision. I agree. They really are. And you want somebody to blame, right? You want someone to take the blame rather than just saying we have things in place that have led to this mess. And those structures need to be brought down, not necessarily a complete party one way or the other. You know what I'm saying? So can of soda I could get $19.90 for 35 cents, 50 cents. No way. 35 cents in 1990? I don't know if I believe that. Really? Was it 35 cents? A quarter and a dime? Are you kidding me? Were they glass bottles? What? What's going on with that? I'm not sure. But yeah, no, you don't have to tell me, people. I went to Target last night. I went to Target and I bought 3 things. It was $100. And I just stood there and I was like, I'm sorry, what? I'm sorry, can we check the price again? I didn't buy anything with gold in it. You know what I'm saying? So, I mean, I hear you. I totally understand. It's, it's kind of a weird situation going on out there, but we've got some problems with some companies for sure. We've definitely got some problems with how that's going about, but I'm not really sure that that's a economy thing. I think that may be a corporation thing. But I hear you. Cans of Walmart soda in the machines are 25 cents in the early. Really? Are you kidding me? That's awesome. I'm going to be Googling that picture. Like, show me a can of soda for 25 cents. It's the same here. Well, there you go, Deborah. Yeah, there you go. I think the businesses that like hook you on stuff, like, I'm not going to name any businesses here because I could get reported again for brand issues. But if you pick a business, they're kind of, getting into trouble for the price gouging situation. There are a lot of lawsuits being spread around as well, but they take a long time. So it's definitely an issue. Shasta. Oh my gosh, Shasta. What? Is that like RC Cola? Is that? What is Shasta? I don't know. Oh my goodness gracious. Quarter for off-brand. Really? Really? Yeah, go for it, Friday. You go ahead and you say the names. I used to search the couch for change to buy a burger meal. Really? Oh my gosh, that's a great story. 97 cents per gallon. Okay, all right. I remember Shasta. Oh my gosh, would it be feasible to break up a company like United Health with antitrust lawsuits? I tell you, if it's possible, someone's working on it. I'll tell you that much right now. If it is possible, people are in a room right now trying to figure out how to do it. So I wouldn't doubt it. It could absolutely. I know. I need to Google Shasta. It's ringing a bell, but I'm kind of oh my gosh. I'm kind of in the sticks out here, so we don't get all of your big city sodas like Shasta. We don't have that. We were never tab people here. Oh my goodness. Will cost consumers. Yeah, the whole tariff situation. Look, I'm not into, numbers. I'm not a numbers person. But what I do know are tariffs, that's not good. That's not good stuff. If you want an explanation on that, you'll have to ask. But what I do know are tariffs, Yeah, that's not good. That's not good stuff. If you want an explanation on that, you'll have to ask one of the other big creators out there instead of the one going through the court documents. If there's a lawsuit about tariffs, I could tell you about it. But other than that, they're no good. I just remember what happened with our farmers with China during Trump's presidency. So that's what I keep in the back of my head. That's all I know. It's all good soda. Oh my goodness. Yeah, exactly. I'm pro farmer. I am pro agricultural world, and so that will not change. Exactly. Yeah, we've got a lot of Shasta has Mr. Pibb. Mr. Really? Okay. Fago, really? It's like Daddy wants to raise. Yeah. So yeah, I'm not a big fan of that. I don't know that tariffs are really the answer here. So, and also there's like a whole bunch of economists that said that as well. Now I leave it up to the experts. I am not an expert, but if you've got like 50 experts saying this is a bad idea, it might be a bad idea. I mean, I'm just putting that out there. just throwing that out there, okay? If like the people that do this as their job are saying this is a bad idea, like I would listen to them. So, oh, I know. A lot of farmers are, and it again, I'm not going to be able to make a blanket statement, but I know a lot of farmers have signed for Trump, and to each their own. But for me, I don't know that that's the best. You missed tab. That's funny. Just instituted dynamic pricing. Really, that's interesting. Blanket tariffs. Yeah. I mean, again, I'm not a fan. Not a fan of the tariffs. Related words Trump knows literally. Yeah. I thought you said fries. I thought you said Mr. Trump fries. Oh my gosh. Mr. Trump at McDonald's. I will just I need to scrub my brain. Come on. Come on. We all know you're not serving those fries up. You're not burning yourself on that fry oil and putting the salt on, getting yelled at for putting on too much salt. We know that that's staged. Come on. McFellin. Oh my gosh. I mean, come on. Where's his hairnet? We had to wear hairnets. Where did his hairnet go? Oh my gosh. I want French fries. Oh my gosh. Yeah, I know. It's interesting. I don't know if he messed him up or not, but what was he doing? Why? What? I thought he was a KFC fella, and then now he's at McDonald's. What's he doing at McDonald's? Out of all the places you could be, does he feel more protected there at McDonald's? It just cracks me up. Oh my gosh, it cracks me up. I'm not trying to be rude about it. I just think it's interesting to have a presidential campaign, the former president with some French fries. If anybody had done it, I would be laughing. But particularly, liberals are the worst people in the world. Really? I mean, in the whole world. Really? I mean, and how do you define liberal? I mean, what do you mean? Webster's dictionary liberal or what? I like to be liberal with my cheese. You know what I'm saying? Does that mean I'm a bad person? You gotta figure that out. Oh my gosh. McFellin. Oh, she said she worked there. Right. Yeah, I think she... And that's one of the things you have to remember about prosecutors. You can take the prosecutor out of the courtroom, but you can't take, it out of your human DNA. And she's going to be out there, sending some burns. She's got some good burns that she's saving up. I think we're just starting to see the beginning. She knows how to bait people. You have to know how to bait somebody on cross-examination. That's what you do. You want them to screw their story up, you bait them and you egg them on. And she knows how to do that. So that's great. And his job is to not to take the bait. And that's the thing. If he hadn't taken the bait, that would have been very helpful for him. But he didn't. He took the bait. And then he's messing around with McDonald's fries. Oh my gosh. Yeah, I mean, I don't care. I don't care where she worked. Who hasn't worked some kind of fast food? If you grow up in a family that's not super wealthy, like Mr. Trump, you're going to be out there working those jobs, trying to put, food on the table and pay rent. I mean, that's just what you do. And so I don't know, I don't know what his his deal is. Like, it's really upsetting to him that she didn't list McDonald's on her resume. Like, I didn't put Wendy's on mine, you know what I'm saying, or Donut Land. Like, I didn't I didn't do that. When I was working for a law firm, they weren't like, oh, you know how to make donuts, great. Like, that's not, that wasn't a thing. So, it's funny. Taco Bell, absolutely. Oh, Taco Bell. See, I promised to never work at Taco Bell because I wanted to eat there. Like, if you work at a place, you're not going to be able to eat there very easily in the future. Oh my gosh. Well, right, exactly. Those places. 10 years. Well, right. So, oh my goodness. Oh my gosh, A&W. Oh my goodness. Retail. I worked at a gas station with a pizza place and liquor. Oh my gosh. I tell you, Just Josh, I tell you what, I worked at a gas station, my friend. I did the graveyard shift at a gas station when I was 18. And it was right next to a ladies of the evening dance bar. Okay. It was right next to it. So about 2:00 in the morning, everyone's coming over with $50 bills, getting a pack of gum and asking for ones for change. And I'm like 18. And it's 2:00 in the morning. I'm like, oh my gosh, I need to get a better job. It was a location issue. I should have picked a different place. I know. And sometimes I didn't want to take the money. I was like, what? Then these gorgeous ladies would come in with a stack of ones, getting a, soda pop. And I'm like, hi, how's your night been? All right, thanks. Oh my gosh. Yeah, I mean, it was just down the road. Oh my gosh, my mother still hasn't forgiven me for that one. Hey, you make your money, As long as it's legal, do what you got to do. But I'm just saying, yes, they did, Kaya. Sometimes you're just like, this one's on the house. You can just have that Coke. Here's your pack of smokes. Oh my gosh. I know. And I would run out of ones. I'm like, I don't have access to the safe, people. Use quarters. Oh, I know. So I digress. Oh my gosh. Oh my goodness. Memories. Reminds me I need to go get gas today. So I go back to my old stomping ground. Oh my goodness. Well, I know, right? You put the quarters. I don't know about you guys, but if you've ever been to one of those places, but it's flipped where it's the fellas dancing. We always had this rule that you put your quarters under your mug. So they would get really cold and then you give them the quarters. It only works on the male ones, all right? Don't do that to the ladies, all right? That's rude. But the male ones, that's all right. Wait, I've said too much. Oh my gosh. I can't. Don't do that to people, all right? Cold quarters, that's nothing to laugh about. Oh, it really did take a turn. At that point, everybody, I should probably sign off here before I get myself into too much trouble, all right? All right, keep your quarters warm if you're going to be giving them to somebody else. Oh, with that, everyone, let me go ahead and sign off for today. Oh my gosh, getting into trouble here. Well, thank you all for coming and hanging out with me. So I will have this up on my Tube of You as soon as possible. So we will have this available, the entire complaint that I did just read through. So with that, I will sign off for now. Take care, everyone. Have a wonderful day, and I will be back before you know it. So